Good morning, everyone. I would like to open today's meeting. Welcome to everyone here in Carson City, anyone that would be joining there in Las Vegas, and of course, anyone watching online, either through our Nellis website or through YouTube. With that, Committee Secretary, please take the roll.
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson. Here. Hardy. Here. LaRue Hatch. Here. Marzola. Present. Moore. Here. Nadeem. Present. Orentlicker. Here. Roth. Here. Urick. Here. Chair Miller.
Here. And with that, I'll just address a few housekeeping issues before we begin. Again, asking everyone to turn down their electronics so that it doesn't disrupt anyone during the presentations. Again, today's agenda is posted on Nellis. You can also view it on Nellis, and it will have the phone numbers for those wishing to testify or make public comment by phone. When testifying or presenting or making a public comment, we do ask that you say your name and spell it so that we have it correct for the minutes. I will take public comment at the end of the meeting. With public comment and testimony, we ask that you keep your comments to 2 minutes. You are also more than welcome to always submit any of your comments or additional comments by paper. With that, just a reminder that public comment is restricted for comments for things that are under the purview of this committee. So public comment may be restricted for speakers who drift off of that topic when addressing the committee. As a reminder, the committee is not appropriate, it's not an appropriate venue for all topics. We do not have jurisdiction to discipline specific peace officers, judges, government employees, or any other specific person. For this reason, please refrain from making reference to specific individuals in that context. Again, I expect courtesy and respect for all interactions that occur in this committee. And with that, I will go ahead and open up our first agenda item. The first item today is a presentation on the overview of the Department of Indigent Defense Services. So with that, I will welcome our presenters up to the table, give you a few minutes to get settled, and ask you to introduce yourselves when you are ready to begin.
Good morning, Madam Chair and members of the committee. Thank you for having us this morning. Nice to see you all, many of you again, some of you for the first time. My name is Peter Handy, Peterhandy. I'm the Executive Director of the Department of Indigent Defense Services. Here with me is Brenda Roberts.
Good morning. My name is Brenda Roberts, Brenda Roberts, Deputy Director at DIDS.
And this is meant to be kind of a high-level overview of what the department does, who we are, what our major projects and initiatives are. Really just a reminder for those of you who already know what we do, and an overview for those of you who might be new to the department. First, who we are. Essentially, the department has 3 main components. And first is me as the executive director, 2 deputy directors, 6 staff members, and we have various contractors performing oversight functions and other duties. Second is the Board on Indigent Defense Services. That's a 13-member voting board that promulgates regulations. They also provide direction and advice to the department when we're trying to make decisions, help improve indigent defense. They're more familiar with a lot of these rural counties. They have representatives from the Nevada Association of Counties, each chamber of the legislature, the governor's office. So it's a varied board, a lot of diversity involved. Third is the Nevada State Public Defender's Office. The current Nevada State Public Defender is Andrew Coates. Currently, they only provide services in White Pine County, though they will begin services in Humboldt County in July. What we do. Essentially, we only have 3 main objectives. That's ensuring that indigent defense persons accused of crimes receive qualified, effective counsel. This is essentially us fulfilling the mandate of the Sixth Amendment of the Constitution and the Supreme Court decision Gideon v. Wainwright. Second is we're ensuring that the defense systems are sustainable and appropriately resourced. So we're talking about offices, contractors. Each county does it a little bit differently, and we want to make sure that each county's system is going to continue to work best for the clients and work sustainably into the future. And third is to ensure that individual defense attorneys are appropriately and equitably compensated, that they're trained, that they're well-resourced. And here's a bit about why we do it. Obviously, we're statutorily mandated to do these things. Otherwise, we'd probably be a little harder pressed to do our jobs well. Really, Chapter 180 provides the structure and obligations of the department, including the board. Chapter 7 provides some payment structure for how attorneys get paid for selected counsel and the mechanisms for those appointments. Chapter 34, the Nevada State Public Defender's Office currently maintains an account just for the payment of post-conviction counsel costs. And then our regulations are codified, or supposed to be codified in NAC 180. Those are regulations promulgated by that Board on Indigent Defense Services. And finally, and of course, is the United States Constitution, Amendment 6, and Gideon v. Wainwright. And a bit about how we do it. So these are our main kind of programmatic outlays. So first is oversight. We have 3 outreach advisors. 2 of them are part-time, 1 are full-time. They're hired on a contract basis, and they visit every county and try to report on the performance of every attorney that's appointed to defend indigent defense persons. They do written courtroom report visits, they do interviews, they talk to judges, district attorneys, different attorneys in the courtroom, sometimes clients, to get a really good idea about how well these attorneys are performing, whether there are any deficiencies, and how we might rectify any deficiencies that they observe. Second, we review complaints. So we are the complaint department when it comes to indigent defense services. When we receive those complaints, we review them for whatever deficiencies might be raised, relay those to the attorneys as appropriate, or oversight advisors to conduct further analysis or investigation into any of those complaints. The other main portion of this is the reimbursement. As you've heard before, this works kind of like a high deductible health care plan. NRS 180, I think it's 006, creates caps on the amounts that each county will pay for the provision of indigent defense services. So this is kind of a joint operation where the county provides the services up to a certain amount, and then the state pays for any remaining costs for those services for indigent defense. After a review of the reported expenses, we receive quarterly reports from each of the counties, as well as an annual report. Once they've exceeded that maximum contribution amount in the quarterly reporting, then we start reimbursement for each of the counties that have exceeded their maximum contribution amounts. The big third part of this is workloads and attorney effectiveness. The National Center for State Courts conducted a workload study, primarily using Delphi method, to identify appropriate case weights, trying to determine how much time an attorney would spend on the average criminal case for varying case types, and then tried to determine how many hours is appropriate for an attorney to work over the course of a year. And we try to model how, kind of the ideal amount of time an attorney should be spending to be a full-time equivalent. These are attorney hours that are utilized in the study, which is confusing for a lot of people because a billable hour isn't quite the same as the average working hour for a staff employee. Second part of this is legal server time reporting. We're obligated to maintain a lot of data, and we require attorneys to provide that data to us. Ideally, in the future, we'll be able to analyze that data and improve both the workload data that we have to try and improve workloads, improve the amount of accuracy that we have for the amount of time it takes to handle that average kind of case, and to improve, really to hopefully identify if there are any issues for a particular attorney's performance or a particular system's performance when compared against other systems. And the third part is reviewing attorney requests for resources and attorney billing. For attorneys that are appointed and don't have a designee in the county, we review all of their billing before it goes to the county for payment. So we have an opportunity to see how much work attorneys are doing on cases, what kind of work they're doing, ensuring that it's appropriate work that they're billing for, and also ensure that they're actually getting paid appropriately by the counties. The other part of that is pipeline development, because as you already know, there's a huge shortage of professionals in rural Nevada. That definitely includes attorneys. We've been provided funds from DETR to have the LASSO program operational. We've placed several externs in different public defenders' offices. It's now available in summer, spring, and fall. If you know students at any law school, it doesn't have to be just Boyd, though Boyd's our primary partner. They would be eligible to receive funds for this, and it ranges from $6,500 up to $15,500 if you accept a job offer after graduation in one of our rural offices. And as an additional stipend, there's another $6,500, I believe it is, for bar preparation materials. So if you get somebody out of law school, they've accepted a job at a public defender's office in rural Nevada, they can get up to $15,500 plus another $6,500 to help study for the bar, pay for a bar prep course. You want to handle training? I'll pass it to Brenda for training.
Good morning, Brenda Roberts. So the state bar requires attorneys to take a minimum number of continuing legal education courses every year, and we require that of those 5 hours be relevant to indigent defense services in order to help ensure that defendants are getting the effective assistance of counsel that the Sixth Amendment guarantees. One of the ways that we try to make it easier for our attorneys is by holding annual in-person conferences. This year will be in Reno the first week of April. We bring in legal experts from around the country to train, provide insight, and to share best practices in various areas relevant to criminal law and indigent defense. We also provide virtual continuing legal education. That is 1 to 2 hours every month of Zoom-style CLEs, or continuing legal education courses. And we do that to provide sort of a continuous stream of information, and because it can be hard for some of our more rural attorneys to attend in-person conferences with the court schedules. We also do ad hoc funding for nationally, to allow attorneys to attend nationally recognized programs, such as the National Criminal Defense College's 2-week trial academy. Mountain Skills has also developed, or Mountain Trial Skills Academy in Utah is another one that we send folks to. And we do have some death penalty CLEs or conferences that we are able to send folks to this year.
Peter Handy. So we also provide resources to help ensure that defense counsel really have kind of the best tools available to them. Thanks to the Interim Finance Committee and Legislature, we've been able to get the Justice Text Audio Video, that's like the primary thing, and I put things in reverse order on the slide, which is throwing me off. But the Justice Text Audio Visual transcription software is apparently a game changer. This is an AI-supported tool that transcribes video recordings or audio recordings that are made. This is really useful in reviewing body-worn camera footage. Many cases now have several hours of body-worn camera footage, and attorneys are often required to not just watch it once to see what's there, but to watch it an additional time, make sure they didn't miss anything, another time to annotate it, timestamp it, try and identify where the particular issues are, and it really creates a burdensome amount of time to have to review that several times before potentially going to trial. This software creates timestamps in videos. It transcribes anything that's spoken. The functionality is just is really unbelievable compared to where we were just several years ago reviewing body-worn camera footage and other audio and video footage. It's saving attorneys a lot of time. They've already started reaching out saying that they're having excellent results with this system, that's saving them a lot of time, that they're able to work a lot more efficiently with cases with a lot of body-worn camera footage. I'll just also mention briefly we provide Westlaw as a legal research tool to attorneys that provide indigent defense services in rural Nevada. And we use Legal Server as a case management system. We offer that at no cost to attorneys as well. We do require that they keep their time in this system. That way we have a uniform data collection tool on our end. And it also provides them with some ability. They either, one, don't have to go and pay for their own case management service, or two, it provides them with some backup or additional functionality they might not be using from their own case management software. So some of our new initiatives. First is creating uniform systems and forms. We've been working creating new billing guidelines to help improve the speed of review, create uniformity in the system so that everyone that's a stakeholder kind of knows what the billing system is going to look like, what kind of things are payable, what kind of things aren't payable, what kind of things are appropriate to bill for, what kind of things are not appropriate to bill for. And this is really helping create clarity for the attorneys who are doing the billing and expecting to get paid for the things that they're billing, clarity for the counties who are paying these bills and want to be sure that they're paying for appropriate services that are being rendered, and to help improve consistency and hopefully speed up the review in our office and improve payment from the counties to these attorneys. Really, we want to ensure that these mostly small business or solo practitioners are getting paid promptly because they really do rely on these paychecks. We're also going to be rolling out some new forms in the near future to help streamline that process as well. And social workers for public defenders. Really, holistic defense assists the whole person. That is the newest model, client-centered representation. It is the gold standard for criminal defense services. When you represent the whole person rather than just helping them with a criminal case, it helps reduce potential sentences, recidivism. Look to things like the Bronx Defenders, the model of this. It's been shown to have good results or promising results. We're hoping to have social workers or case managers or some sort of paraprofessionals working in the rural counties, help coordinate care, counseling, getting clients to and from court, to and from their appointments. And this is really going to take a load off of the attorneys or investigators that are doing this now in offices, and helping the attorneys work their client cases more directly in their legal cases. And it's also going to help coordinate care better for clients who are, in many cases, unable to either locate these assistance programs or these services on their own. And with that, I'm happy to take any questions you might have.
Thank you for your presentation. And I will start with, well, first I'll say I love that model right there of having the social workers involved as the wraparound. When I ran a prisoner reentry program, it was the same thing. Every program I ever ran, I hired social workers. They really are the heart and the backbone of so much public service, and to help navigate and connect all those additional services in addition to, of course, the actual defense that is being provided. So can you just give a little more detail about that? Have you started this, or are you still planning and about to start? And just tell me more about that program.
Peter Handy, yes, I would love to. So we have been working with NPHF, the Nevada Public Health Foundation. They already have some piloting programs that they're working on in different rural jurisdictions. So they have some kind of processes going in Nye County. They've talked to people in Esmeralda County and Lincoln County that are interested. We're hoping to partner with them. Part of the GovRec budget, the initial one that I've had a chance to review, provides for $300,000 in funding from opioid settlement funds. We'd hope to work with NPHF to both build out a new program. Obviously, there hasn't been a tried, tested version of this before. Every county is a little bit different in the resources they have available and the needs of each of the offices. So we'd be working closely with the interested counties, try to get a small kind of pilot program put together. We're thinking a lot of it would be kind of managed by a social worker, and there would be case managers working for or with that social worker in each of these rural areas as people are available, and really trying to get the data-driven results, right? We want to see what the differences are before having the social worker or those care coordinators in the offices working with clients, and afterwards. But yeah, NPHF has been fantastic to work with in the past, and I think they'd make a great partner in this going forward.
Thank you. I appreciate that. And so you're initiating it just for the rurals right now, but do you ever see expanding it throughout the entire state? Again, this is individuals going through this process. We often forget that they have a family that's involved in this process as well, and children that are involved. So do you ever, is this just right now piloted toward the rurals because of the need, or do you think this will expand out to the entire state at some point?
I think it's something that indigent defense is moving in this direction. It will at some point be throughout the state. Already offices in Washoe and Clark County have social workers involved. A few of the rural counties, Carson City has a social worker involved, or has, maybe it's a part-time. I'd have to speak with them again about it. Elko County has a social worker in their office. So we're already seeing the shift. This is trying to get resources into these rural areas to begin with to see how well it's going to work, how remote services might work, because there really are a limited number of social workers available right now, and most of them are concentrated in Washoe and Clark counties. It's harder to get them to these more rural counties without long distances, the same reasons we have for getting attorneys or accountants in these more rural places. So we're trying to work on different models and seeing what might work best. I think once we've kind of figured out those best practices, absolutely, this is something, like I said, this is something that we're going to need to move to in the future. The benefits are really, we can't even realize them now because it hasn't been tried on that large of a level yet.
Thank you for that. And I wish you the best in launching these programs. With that, we'll move to member questions. We'll start with Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. It's really great to see all the good work that you've been doing since the board was implemented, I believe in 2019. My question is in regards to specific issues in the rural counties, since the department services the rurals outside of Washoe and Clark County. What do you see as some of the greatest barriers to access to justice right now facing the department and your attorneys who are practicing in the rurals?
Peter Handy, thank you for the question. I think there are a few issues related to access to justice. Primarily, it really is just there aren't enough attorneys in Nevada's rural counties. It's not even for criminal defense. There are also a shortage of prosecutors, a shortage of divorce lawyers, a shortage of property lawyers. It's really hard to find legal counsel in a lot of Nevada's rural counties. For low-income persons who can't afford attorneys anyways, there aren't that many legal aid organizations that have a large presence in the rural counties. I think that presents some access to justice issues. There's also issues, I think, with our state courts aren't very uniform. So if you're in a particular county and you have an issue in that county, there might be local rules that are affecting your case, whether that is like a landlord-tenant case or a criminal case. And knowledge of these rules can be complex, and since they vary from county to county, there can be a big impact on somebody's case without them having the kind of level that we do as attorneys to be able to understand what those rules are and how to actually utilize those in those counties.
Thank you. Our next question is from Assemblymember Ordlicker.
Thank you, Chair. Thank you for your presentation and the very important work you do. I'm curious if you could tell us a little bit about how things are going with the Davis versus state consent settlement. And I know there's a special monitor and who reports on compliance. So what is the monitor reporting in terms of compliance?
Thank you for the question, Peter Handy. For the record, the monitor's reports have been they've been very useful for the department. So typically the monitor is spotting areas of non-compliance, and then the department's working to address those areas, often with interaction with the legislature and the governor's office, trying to figure out how we can meet those compliance issues. Right now, the kind of two outstanding things, the large kind of elephants in the room, are the workload study and compliance with the number of attorneys needed in each of the rural counties. And there's still some issues about pay parity and equity. At this point right now, state public defenders, attorneys are still some of the lowest paid, if not the lowest paid, employee attorneys in the state. I think every county office pays higher for their entry-level attorneys than the state public defender's office does, so there's an equity issue there. The other part is really the workload, which is why we have this substantial pipeline effort, trying to get people to either entertain taking employment in rural counties, hopefully moving to rural counties and opening up practices there, even if they're not working in indigent defense offices. Because like I mentioned before, there's such a shortage, and there really are so many issues that are really needed to be addressed by attorneys in the rural counties. That's where we're providing a lot of our focus. That's most of the monitor's reporting, though, recently has been focused on that.
All right, thank you for your presentation. I don't see any other questions from members, so with that, I will go ahead and close the presentation. Thank you. Next on our agenda, we have the presentation of Assembly Bill 17. Assembly Bill 17 seeks to revise provisions relating to writs of garnishment. It is on behalf of our state controller. Welcome back. And to those who don't know, Controller Matthews actually served in this branch for, was it one session or two? One session, okay.
That was all I could handle.
Us too. So with that.
Burned.
Yeah, it's not that early. It's 8:24. So with that, Controller, go ahead and please introduce yourself and who else is presenting with you. Whenever you all settled in, you may begin. And for those who aren't clear, the Controller and I actually are friends, so we're good. Please proceed.
Good morning, and thank you for that very warm welcome, Chair. And thank you. Good to see you, committee members. My name, for the record, is Andy Matthews. That is ANDYMATTHEWS. I am the Nevada State Controller. The gentleman next to me is Chief Deputy Controller James Smack. I'll let him spell his own name when it's time for him to speak. We're very delighted to be with you this morning. I'm going to give a very, very brief overview of the Controller's Office, and I'll turn things over to Mr. Smack for our bill presentation. So the Controller's Office, or the Controller, serves as the Chief Fiscal Officer of the state and is elected to a 4-year term. The authority for the Controller's Office is derived from Article 5 of the Nevada State Constitution. I am one of 6 constitutional officers, and the Controller is elected by and accountable directly to the citizens of Nevada. Our office has currently 46 team members. 2 of those are non-classified positions. The other 44 are classified, and we are organized into 4 divisions. Those are debt collection, fiscal operations, financial reporting, and information technology. Just a quick shout out to our team. We've got a lot of very hardworking and talented people in the Controller's Office, and I just want to acknowledge and thank them for all their hard work and effort. And with that, I will turn things over to Chief Deputy Smack. Thank you.
Thank you, Controller Matthews. For the record, James Smack, Chief Deputy Controller. That's spelled James Smack, for the record. And a very brief overview on the genesis of this bill. Every 2 years, when we're putting together our bill drafts, I go to our team and I say, what are we looking at in things that maybe in NRS that we might want to have a discussion about changing, and where does it make more sense to do it a little bit different way? And one of the things that one of our staff members brought to us was the garnishment process. It hasn't been looked at for a number of years, and the fact of the matter is that when we do receive the garnishments from the sheriff's office at this point in time, and a quick definition on what a garnishment is. A garnishment is a writ that comes based off of a judgment made against somebody who owes some kind of a debt to another individual. It can be a private debt, or it could be a credit card company. It could be any one of a variety of things. And the judgment provides for a garnishment to garnish a state employee's wages, or whoever the defendant's wages are. And that's when we would receive the garnishments. And on average, we've received maybe 2 or 3 a week. So it's not a significant process for our office, but the fact is about all we can check in our office is whether the person is a state team member, and we can verify their tax ID number, or at least last 4 digits of it. After that, we have to involve payroll in the process. Hence the thought of moving this to the Department of Human Resources Management. I've spoken with individuals in DHRM and within state payroll, and we have both come to the conclusion it does make a little bit more sense to have the garnishments delivered to DHRM. It's not a very difficult thing for the sheriff's office. All they have to do is not take the elevator ride to the 2nd floor of the building, since DHRM is now in the same building as we are. So all they have to do is deliver that garnishment at the 1st floor, and it saves them the elevator ride. And if you have ever been in the elevator at the building on Musser, it's a little bit spooky to begin with. So we might actually be alleviating the fear of a couple of sheriff's deputies at this point in time. So with that, I'll answer any questions that you have about this bill. But that's pretty much just the base gist of it. It's not anything that's going to be a real complicated matter. Our office is perfectly prepared to train state payroll on our processes of how we process the garnishments and everything like that. It does require notarization. We do have 2 notaries in our office, so if DHRM doesn't have an active notary, they could have the time to get that person activated again, and we'd be more than happy to provide the notary services for them as well. So I think that covers all the fine points of what's been discussed about this bill, and I'm just going to turn it over for questions at this point. Thank you.
Thank you. I'm thinking we should have the Controller's Office in here more often. With that, our first question will come from Assemblymember Hardy.
Thank you, Chair, and it's good to see you, Controller Matthews. I served with him, and it was quite an honor, and so glad that you're in this position now. Just a couple of questions, just a little more detail. So are there the staff, et cetera, in this division that will be able to process these? And it also mentions that prioritizing the claims or the garnishments for child support. Do you feel like it would help expedite those and get those processed more quickly by moving them?
Again, James Smack, Chief Deputy Controller for the record. And question on decorum, Madam Chair, should I go directly to the Assembly member? Thank you. All right, Assembly Member Hardy, to your question. As far as the breadth of payroll and DHRM to be able to handle the processes aren't really that time consuming or difficult. It's just going to be a matter of a little bit of training, which our office is perfectly willing to provide to them. The process is receiving a garnishment, verifying whether it's a state employee or whether it's somebody else. I mean, if it's somebody else that derives their benefits from PERS, then we fill out a very quick interrogatory saying, this is a PERS team member. This garnishment needs to be served upon PERS, that type of thing. So there are situations, inmates, same thing, has to be served on Department of Corrections. So there are a few things that we can verify through our office, but primarily, if it is a state team member, we have to go to payroll anyway and get all the information. We don't know what a state team member is paid, necessarily what their position is, or how long they've been with the state, or what have you, or if they've been terminated, what their termination date is. So there's just a lot of information that we already have to derive from payroll. So it made a lot more sense to just have payroll assume the process. It's not going to add too much to their plate as far as that goes. As I said, we're only looking at maybe 2 or 3 of these a week on average. It's not a very intensive process, but it's a process that maybe at one point in time, and I'll opine that maybe at one point in time, payroll was part of the controller's office. In many states, state payroll is distributed and handled by the state controller's office, but in Nevada it is not. So I can't speak to the genesis of why it was created this way, but it hasn't made an awful lot of sense for it to come to the state controller for a while, since we don't administer payroll in the controller's office. So I think that covers your question, Assembly Member. If there's something that I missed, let me know, please.
Yeah, I'm hearing greater efficiency, so that's always a good thing. Thank you.
Thank you. And I'm hearing a few things too. So just to clarify, and I appreciate that you all gave like a brief overview of the controller's office. It's probably one of the state's functions that are least understood, one of the offices. And so it's my understanding that your office is to collect basically money and bills from other state agencies or other entities that our state works with, not individuals. Is that correct?
Madam Chair, thank you for that question. James Smack, Chief Deputy Controller for the record. I think you're might be getting into like our state collections process. We do collect monies from individuals as well as businesses and that type of thing. We do administer state debt collection for all the state debts that are aged 61 days old or older. So that can be individuals. That could be someone as simple as somebody who bounced a check to the DMV, to somebody as something as large as, say, there was over $1 million settlement for the petroleum fund based on a cleanup that they had to do. So those could really run the gamut from just a few dollars to millions of dollars. So it's a little bit different than what we're talking about here, though. So I just wanted to clarify that, though, as part of the process of our office. Yes, we do have a debt collection division. We do collect debts on behalf of the state.
Thank you for that. But with this, going back to your discussion with Assembly Member Hardy, what I am also believing or understanding is it also will create a level of privacy for our state employees, because again, these are personal matters, HR issues, and maybe not something that would be appropriate. Would that be a fair statement or assumption?
Madam Chair, James Smack, Chief Deputy Controller, again for the record. Excellent point, actually, because that was something that I didn't cover in my presentation, that anytime we have to gather information from state payroll on behalf of a state employee, there's information going between one person and a second person. This would take that exchange out of the equation. Now, all of our team members have been through background checks and that. I'm pretty comfortable. We have trustworthy people working for us in the controller's office. Dear God, I hope so. But the fact of the matter is that anytime there's any kind of an information exchange of personal and identifiable information, if we can quash that exchange, that does provide for more security for our state team members. Yes, absolutely.
Thank you for that. I don't see any additional questions for members. So with that, I will go ahead and open it up for testimony. We will begin with testimony in support of Assembly Bill 17. So if there is anyone that would like to come forward and testify in support of Assembly Bill 17, we'll begin here in Carson City. Not seeing anyone. Is there anyone there in Las Vegas that would like to come testify in support of Assembly Bill 17? Also not seeing anyone down there. Broadcasting, will you open the lines, please?
Chair, the public line is open and working, but there are no callers at this time.
Okay, thank you for that. I just want to go ahead and announce the number because I know sometimes people aren't on the computer as quickly. The number for today is 1-888-475-4499, and the meeting ID is 860-3620-6466. With that, I will go ahead and open testimony here in Carson City for anyone in opposition of Assembly Bill 17. Not seeing anyone. Is there anyone in Las Vegas that would like to oppose AB 17? Also not seeing anyone broadcasting, please open the lines for anyone that would like to call in and provide testimony in opposition of Assembly Bill 17.
Chair, the public line is open and working, but there are no other callers at this time.
Thank you. With that, I will open up testimony in neutral for Assembly Bill 17. Not seeing anyone approach, is there anyone in Las Vegas that would like to testify in neutral? Also not seeing anyone broadcasting, is there anyone on the line that would like to testify in neutral?
Chair, the public line is open and working, but there are no callers at this time.
Thank you so much. With that, I will welcome the bill sponsors if you have any brief final remarks you'd like to make.
Andy Matthews, State Controller for the record. No additional comments. Just want to thank you for your time this morning and for your consideration of this bill. Thank you so much.
Thank you so much. Good to see you. And with that, I will go ahead and close the hearing on Assembly Bill 17. Now, I'm not saying all hearings going forward have to go like this, but kind of the gold standard if possible. I know it's not possible, so. With that, I will open up the hearing for our next bill, which is Assembly Bill 76. Assembly Bill 76 revises provisions relating to cannabis. So I'll give you all a few moments to get in and get settled, and then whenever you're ready to begin, please introduce everyone presenting and proceed.
Thank you, Chair. Are we ready? Our bill is not as short as the controller's bill, unfortunately, but we will certainly try to keep it tight, and we will be fast, but we won't hurry. So, thank you, Chair Miller, Vice Chair Marzola, and members of the Assembly Committee on Judiciary. My name is James Hummon, as I serve as the Executive Director of the Cannabis Compliance Board. I have with me our Deputy Director, Michael Miles, our Chief of Health and Safety, Kara Cronkite, and our Administrative Law Judge, Amy Meyer. It's great to be back in this committee after giving our presentation last Thursday. This agency-generated bill mainly addresses what I like to refer to as a run-the-agency bill. These are operational concepts that we have found would be useful to assist and streamline the operations of the agency. These include changes to the administrative hearing process, clarification on the requirements of ID scanning at cannabis sales facilities, the definition of synthetic cannabinoid. It also adds language to allow for immediate temporary cease of operations due to imminent health hazards, which is consistent with other agencies enforcing public health, and it revises package size limits to be consistent with new possession limits in industry demands. As I noted in the committee hearing last week, we are bringing forward a substantive amendment for you all to review today. In an effort to streamline the presentation of this bill, I'd like to give a brief overview of why the amendment is coming forward and then walk you through each of the amended sections. After that, we'd be happy to take any questions about our proposed changes and any additional section of the bill that members might have questions about. Again, it's a 52-section bill, so we're happy to cover any of those that the members may have questions about.
Okay, so just to clarify, you'll be presenting based on the proposed conceptual amendments.
That is correct, Chair. Yes, James Hum for the record. That is correct, Chair. So I'll kind of walk through the amendments, and then given that it's 52 sections, if the committee members have any specific questions about those, we can absolutely refer back to those, and I have our experts here to help answer those questions.
Okay, thank you.
Thank you, Chair. The general intent of the proposed changes was to address industry and stakeholder concerns on various aspects of the language included in the original bill language, but that also meets our intentions for what we need for, as I said, kind of a run the agency bill. So Section 10, Sub 1, Sub 3 addresses synthetic cannabinoids. The amendment includes additional defining language. This expands what is not included in the definition of synthetic cannabinoids to accommodate advances in cannabis manufacturing while continuing to require board approval for processes to enhance safety. Section 11 adds subpart 5 to NRS 678A 450, authorizing the CCB to issue summons and subpoenas to unlicensed activity participants. The 2023 legislature added statutory authority to the CCB to investigate and take action against unlicensed cannabis activity. After drafting our regs to accomplish this statutory authority, LCB advised that explicit subpoena authority in statute was needed to summon such participants in front of the board for proceeding on such activity. Also, Section 11, Sub 3, notices of violation. We removed language for the board to adopt provisions or regulations for the notices of violations that were originally included in 678A 520. As this section was removed by the proposed amendment in Section 15, this section is no longer needed. So that's more of a conforming change. Section 12, Sub 3, Sub K, pertains to confidentiality of letters of warning, letters of concern, or non-punitive admonishment. This amendment removes proposed language specifically making letters of warning, letters of concern, or non-punitive admonishment not subject to confidentiality provisions. We changed that to address concerns that the release of the aforementioned information could be utilized to negatively impact licensees without a due process right to contest. Thus, the proposed language was removed. Sections 14 and 15 includes changes to the hearing process, the executive director issuing complaints, and inclusions of notice of violation. The amendment removes proposed language providing the executive director authority to issue a complaint. The board maintains this authority with this amendment to issue those complaints. The amendment removes all references to proposed language regarding notice of violation. Additional conforming amendments in Section 11 previously noted, Section 26 Sub 1, Section 26 Sub 2A also removes language referencing notices of violation. The intent of this proposed language provides the executive director authority to issue a complaint, and the additional non-formal complaint structure for notice of violation was found to be in conflict with industry views. Section 20, Subpoena Authority, addresses proceedings in front of the board and gives hearing officers the same power as the board in such proceedings when an order including a subpoena is disobeyed. This amendment reinstates the board's authority to enforce noncompliance with the subpoena. The intent was really a technical amendment that reinstates language providing the board's authority to enforce the subpoena that was issued by the board. Section 26, Letters of Concern, Non-Punitive Admonishment. The amendment removes the authority from the executive director. This reinstates the board as the body that issues complaints, dovetailing with the removal of the other language within the bill, of the removal from the original bill. Section 28, Transportation of Cannabis, removes Section 28 due to redundancy with NRS 678D 440 Sub 1. This will help avoid confusion, and in conjunction with industry input, Section 28 was removed. We had initially included that to clarify. Unfortunately, did not clarify, so we decided to take that out and leave as is. Section 29, Sub 2, Sub B, definition of substantial hazard to the public, time for reinspection, time for hearing. The amendment defines the period of interruption to 2 hours. This amendment addresses concerns that brief interruptions of electrical service will necessitate the reporting of a substantial hazard. This amendment more narrowly defines the requirement to accomplish the goal of protecting public health, and with that reduction, if it's a brief period, we've decided to define that more clearly. Section 30, suspension, hearing, and reinstatement process for substantial hazard to the public. The amendment reduces time for inspection from the by the CCB agent from 10 days to as soon as practicable, but within 2 business days. This also reduces the time for hearing from 45 to 14 days. The proposed amendment addresses the concern that under the prior timeline, licensees could sustain an extended period of closure due to a substantial hazard while awaiting reinspection or hearing. To address these concerns, the board examined internal processes, and the amended language reflects significant reductions in the timeline for reinspection and hearing, with the goal of getting these folks back open as soon as possible. Section 39, sub 7, operating documents and guidelines for cannabis establishments, vending machines. The amendment deletes all language regarding use of vending machines in cannabis sales. The intent was through information gathered from industry and other interest groups. The overwhelming conclusion was that this language regarding the allowance of cannabis vending machines and dispensaries was not needed at this time. Section 40, sub 1, sub B, cannabis packaging. The amendment adds language in 40, sub 1, sub B, prohibiting the use of an anthropomorphic image in cannabis packaging. The proposed amended language includes the term anthropomorphic. The language is added in this section to clarify the types of images provided in cannabis packaging. Anthropomorphic images are images that attribute human characteristics to non-human entities. Think of Joe Camel. That's a good example. Section 40, sub 4, cannabis advertising. The amendment in Section 40, sub 4 removes proposed language, which would have subjected cannabis packaging to the same prohibitions as cannabis advertising. The proposed amendment addresses concerns regarding the proposed additional regulation of cannabis packaging, specifically as it pertains to utilizing images of fruit. This amendment allows the continued use of images of fruit on cannabis packaging. Section 44, sub 2, sub A, maintaining medical cannabis records for 120 days. The amendment basically makes the 120-day retention requirement to not include Nevada cardholders. It would only be applicable to out-of-state medical cardholders, and only information would be provided if applicable. The intent of this was the section was amended to make the request on licensees to maintain records for an additional period as narrowly tailored as possible to serve the needs of both board agents to conduct audits. Because medical card holders are subject to a lower sales tax than recreational consumers, these records are relevant to an audit, and because Nevada cardholder information can be verified, this amendment limits the additional retention time to only out-of-state medical card holders. Section 48, sub 2, limits on ounces, milligrams for purchase. The additional increases in single package limits for concentrated cannabis and topical products, this amends that. The intent was to meet consumer demand for increased single package amounts of topical and concentrated cannabis, and to decrease the cost and the environmental impact of packaging, while also considering health and safety by limiting the increase to products that are not subject to overconsumption. This amendment increases the single package limits for topicals, i.e. balms, salves, lotions, and concentrated cannabis like cartridges. Section 50, cannabis distribution. This reinstates the language removed of the bill. Through discussion, it was determined the bill language will not meet the needs as desired. Therefore, it is appropriate to reinstate the prior language. And lastly, Section 52, sub 3, agreements with tribal governments, ownership and confidentiality of information. This amendment further defines ownership of information received from tribal governments. The intent of this amendment was to clarify and utilize language that more appropriately reflects the agreement that not only is tribal information held in confidence, but this information remains the property of that tribal government. Thank you, Chair and members of the committee, for hearing our amendment. The team is here to answer any questions related to the change that we just brought forward, but also, as I said, very large bill. Happy to go over any of the 52 sections.
Thank you so much for that. And you did a great job of going through quickly and briefly, but also it's a very, like you said, it's a long bill, very technical. So I'm just giving members a moment to digest and Okay, so we are ready to begin our questions. With that, we will begin with Assemblymember Dahlia.
Thank you, Chair, and thank you for your presentation. I have a quick question for the uninitiated on these products. So in the change to synthetic cannabinoids definition, I see there is an exemption now for Delta 9. Delta 9 tetrahydrocannabinol. How'd I do? What is that? Thank you.
Thank you for the question, Chair. Anthropomorphic was the hard one for me. I'm going to kick all of the science questions over to our Chief of Health and Safety, Kara Cronkite. Oh, sorry, Chair. May we go direct? Please. Thank you, Chair.
Thank you for the question, Assembly Member. My name is Kara Cronkite for the record. Delta 9, you could say THC, if that's easier for you. Delta 9 THC is the form of THC that is most frequently referred to when people are referring to the part of the cannabis that creates the intoxicating effect. So when you have the usable form of the plant, it naturally breaks down into this Delta 9 THC. So that would be the natural occurring form. There are other synthetic forms such as Delta 8 THC, Delta 10, just isomers of the same chemical structure.
Assemblymember Cole.
Thank you, Chair. Thank you for the presentation. My question is just on administrative procedures. And so, hi. So my question is, there are various changes in the entirety of the bill related to what would be considered final decisions and subject to judicial review and what wouldn't be. And so I was just wondering if you could summarize what is and what isn't final and subject.
And for the record, is Deputy Director Michael Miles. This just basically adds a layer. That's all it really does. In 21, you authorized us to hire an ALJ. We're just using the ALJ to be the initial trier of fact for any type of disciplinary hearings. That would be a final decision unless someone appeals or the board themselves requests it to come in front of them. Then it goes in front of the board. They decide. Again, that would be a final decision unless they decide to appeal again, and that appeal would go to district court as part of a PJR. And again, even at the district court level, if they don't like that decision, they can appeal again and go up to the appellate or Supreme Court level. You're welcome.
Thank you for that. Our next question is from Assemblymember Roth.
Thank you so much, Chair, and thank you so much for the presentation. My question is in regard to cannabis packaging, and please excuse my ignorance on all of this, but can you go over a little bit what the exit bags are, what their purpose is, and whether or not we believe they're necessary moving forward given the amount of waste I understand they create?
Thank you for the question, Assemblymember Roth. This is Kara Cronkite for the record. Exit packaging is something that the industry came up with as a solution to a regulatory requirement that we have, that all cannabis and cannabis products leave the dispensary in some sort of packaging that is child-proof for multiple openings. So if you think of a pill bottle that you receive your medication in, you can take the top off, and when you put the top back on, it maintains its child resistance. So that was the idea, so that when maybe a parent takes their product home and they leave it out on the countertop, that child at their home wouldn't be able to get into that packaging. Now, the industry has the option of making their initial packaging for each product child resistant, such as a pill bottle or something similar, or what many licensees have determined to be the easier solution is to just take all the products that someone purchases and put them all into an exit bag, which they call, and that bag has that child resistance packaging on it. So it's really up to the licensee how they want to achieve this child resistance for multiple openings.
Thank you. Our next question is from Assemblymember Urick.
Thank you, Chair, and thank you all for the presentation. My question pertains to Section 51, and I did not see any proposed changes to that section in your conceptual amendment. Is that true? Is that section stand as originally posed or offered?
James Hum for the record. Yes, that is correct.
Okay. Chair, just following up on that. My question is...
Are you requesting a follow-up?
Yes, ma'am.
Proceed.
That was, my question is there any concern that maybe we need to tie up any provisions of the Nevada Clean Indoor Air Act with respect to, I'm assuming that they do serve food in these consumption lounges, and that without any specific exception to that in the Nevada Clean Indoor Air Act of consumption lounges being exempted for purposes of being a restaurant, are we could potentially be dealing with a conflict here?
Thank you for the question. Kara, do they currently serve food?
Kara Cronkite for the record. They are serving beverages only at this time, but it is anticipated that they will begin serving food at some point.
Chair, can I just probe one more quick follow-up to that?
I have a few other people.
Okay.
We'll circle back to you, okay? Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you so much for your detailed walkthrough for this bill. So my question is on the amendment for Section 10. In your write-up, you say that we're accommodating advances in cannabis manufacturing while continuing to require board approval for processes to enhance safety. So I just wondered if you could speak to what are those advances and what are the safeguards that you are maintaining to ensure safety?
Thank you for the question, Assemblymember LaRue Hatch. When we review different processes for safety, we have a team of expert scientists. They are registered environmental health specialists, and what they're really looking for is, say that someone proposes a new extraction process. There are certain chemicals that are allowed. There are food-grade versions of those chemicals. We're making sure that they're not cutting corners or using different chemicals that aren't safe for the intended route of administration or safe for the type of extraction that they're doing. And so we are really looking at things that the FDA would look at for these types of procedures. I hope I answered your question, but if I missed anything, please let me know.
No, that is helpful, absolutely. I think I just wanted a little more clarity on the language as well of the bill when you're talking about accommodating advancements in cannabis manufacturing. Are you looking at just listing more very highly technical chemicals that are allowed? Maybe you don't have that language yet. I just wondered if we could get a little bit more detail on that.
Sure, Kara Cronkite for the record. It's just allowing the opportunity for the industry to be more creative. They are much more creative than I am. I'm not capable of thinking of everything that they might want to do in the future. So it's just setting an allowance saying, hey, if you create a process that we haven't thought of yet, we are making it a possibility for you to bring those to us, and then we can review those on an as-received basis.
James Hum for the record. Assembly member, that will also go through the regulatory process, so then we will able to get feedback, hold the workshops before any of that would go into regulation. Thank you.
Thank you. Our next question is from Assemblymember Gonzalez.
Thank you so much, Chair. Thank you all for being here and for the presentation. My question is under Section 30 for the suspension, hearing, and reinstatement process. You reduced the hearing times from 45 days to 14 days, stating that the prior timeline, right. So I was just curious, can you walk me through that? Do you have the capacity to meet this 14-day change and kind of what that looks like? Thank you.
James Hum for the record. Thank you for the question, Assembly member. Yes, we do. We vetted that with our legal counsel as well as Chief Cronkite's team, and we have full confidence that we'll be able to meet those timelines.
Thank you so much. I was wondering if you could walk me through what that looks like, though, like practicality, like making sure that you guys have the capacity to meet that timeline.
Absolutely. Chief Cronkite.
Regarding the reinspection timeline, sorry, Chief Cronkite for the record. Regarding the reinspection timeline, this is very common practice with any health department or public health agency. As soon as the facility says, hey, I have corrected all the issues, we're ready for you to come back and reopen us, staff will do their best to accommodate that request and be there as soon as possible, hopefully that same day. So within 2 business days just allows our team the opportunity to prepare for any travel that might be to more rural, distant areas in Nevada. As far as the hearing timeline, did you want to tackle that?
Deputy Director Miles, for the record. The hearing would just, if we usually have monthly board meetings, so it's usually every 30 days. This kind of situation, we would just have a special board meeting and pull the board members together to vote on it.
Thank you. Our next question is from Assemblymember Ornlicker.
Thank you, Chair. Thank you for the presentation. My question, we've been seeing more and more reports, and I think they're primarily from other states that have longer experience, that we're seeing more health problems than we had hoped with the legalization of marijuana. And are there any things in this bill to kind of get ahead of the curve for us, or did we already anticipated the kinds of problems that other states are seeing, or should we be doing more to make sure we don't have the same unintended health consequences that other states are seeing?
Thank you for the question, Assemblymember. James Hum for the record. So there are a couple things in there, like the imminent health hazard that we're looking to. As I mentioned last week in our presentation, one of our mission statement, one of our chief goals is always health and safety. And so we're part of a national organization, CANRA, Cannabis Regulators Association. And so we frequently meet with them, discuss with other members from other states on potential fixes to some of these long-term health issues that could potentially arise. Again, we're always looking towards that. This bill, more specifically, is more technical in nature, and again, it addresses the imminent health hazard, but not specifically, I wouldn't say, towards, I think, kind of your question and your concern.
Thank you. Our next question is from Assemblymember Hardy.
Thank you, Chair. So I wanted to just make sure I understood the amendment correctly. In section 40, where we're talking about the packaging and advertising, I think we all agree we don't want to be marketing or advertising or making these things enticing to children. So as I heard you, they can use an image of fruit, but not an anthropomorphic image. If you could just clarify that.
Thank you for the question, Assemblymember. Yes, that is correct. No anthropomorphic images of fruit in advertising or packaging.
Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. It's almost the same question. And so my question is how you are making sure with the increase in cannabis sale, how you're making sure that it is not going to affect the children?
I will let, thank you for the question, Assemblymember. I will let Chief Cronkite weigh in as well, but I think kind of to what I just said to Assemblymember Ornlicker, everything we do is geared towards public safety. Again, on the advertising, we want to make sure that there's nothing out there that would be potentially appealing to children. And then additionally, the packaging that adheres to child safety. Chief Cronkite has actually spent a long time working on these issues as well, so I'll let her weigh in too.
Thank you for the question, Assemblymember Nadeem. As Director Hum has mentioned, we work very closely with the professionals of other states, and we look into the research surrounding what products children are getting their hands on. hospitalization records, anything that could be helpful to us in making those decisions. And so the child-resistant packaging plays a big role in that, as well as the images on packaging and advertisements as well, making sure that vape pens and other popular products among teens are not so heavily flavored, like the nicotine vape pens that you see that are very popular among youth. We try to limit those flavorings as well. That's another approach we take. Thank you.
Can we have a follow-up question, please? Thank you, Madam Chair. So I want to follow up with, what about the smoke? Is there any, after use, is there anything in the air that comes? How we can prevent it from the children to exhale, to inhale it?
Chief Cronkite, for the record, currently the way that the law is written, people are only allowed to consume cannabis in a private residence or in a cannabis consumption lounge. So it would be up to the family to ensure that their children are safe and not exposed to the smoke when they're inhaling that cannabis. And we don't allow anyone under the age of 21 in a cannabis consumption lounge or any other establishment.
Thank you. Our next question is from Assemblymember Urick.
Thank you, Chair, for the follow-up. Along my earlier line of questioning, I just want to make sure that we don't unintentionally create a conflict in the statutes. And so I'm hoping that perhaps we might be able to address cannabis lounges as an exception under the Nevada Clean Indoor Air Act, if you might want to address that.
Yes, thank you for the question, Assemblymember. That is actually what we were trying to do, was really, I think that it might have been missed when they were actually, when cannabis consumption lounges were actually legalized. So this really, to me, is just a conforming change to enable that to occur in the 40 specific cannabis consumption lounges. Thank you.
Okay, thank you for that. Thank you for responding to our questions. With that, I will go ahead and open it up for testimony. So we'll start here in Carson City. Anyone that would like to testify in support of Assembly Bill 76? Again, I ask that you keep your comments to 2 minutes. Please state your name, spell it for the record. And of course, there's 3 chairs up there, so you may fill them, and then we'll move to Las Vegas and then, of course, to the phone lines. So when you're ready, please proceed.
Good morning, Madam Chair, Madam Vice Chair, members of the committee. For the record, Chelsea Capurro, that's CHELSEA, Capurro, CAPURRO, on behalf of the Nevada Cannabis Association. I think first and foremost, we want to thank Director Hum and his team at Cannabis Compliance Board. They worked with us for many hours, lots of meetings on this. And so we really appreciate the time and effort that they took on this, no pun intended, on time and effort. And just want to say thank you. We know that obviously this is a joint collaboration. They've listened to us and taken into our feedback and account, and we appreciate it, and we are here in support.
Good morning, Harrison Bond, BOHN with Brownstein on behalf of Deep Roots Harvest. Deep Roots would like to echo the Nevada Cannabis Association's support and testimony and say that we too appreciate the CCB's collaboration on both the bill and today's amendment. Deep Roots urges your support, and thank you for your time.
Thank you. Not seeing anyone else here in Carson City. Is there anyone? I don't see anyone in Las Vegas. So broadcasting, will you please open the line?
If you would like to testify in support of Assembly Bill 76, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 76, please press star 9 now. Chair, there are no callers choosing to testify in support at this time.
Thank you. Then I will open it up for testimony in opposition of Assembly Bill 76. Not seeing anyone here in Carson City approach in opposition. There's no one in Las Vegas. Broadcasting, is there anyone on the phone line?
If you would like to testify in opposition to Assembly Bill 76, please press star 9 now to take your place in the queue.
Good morning, Chair Miller and members of the committee. My name is Jennifer Atlas with the American Cancer Society Cancer Action Network. I'm calling to express our opposition to AB 76, specifically Section 51, which amends the Nevada Clean Indoor Air Act to allow the smoking of cannabis in cannabis consumption lounges. This bill weakens Nevada's smoke-free protections by creating exemptions that increase public exposure to secondhand smoke, including workers in these establishments. We urge this committee to reject AB 76 to prevent the erosion of Nevada's clean indoor air protections and ensure that all workers and patrons, regardless of the substance being smoked, are safeguarded from the proven dangers of secondhand smoke. Thank you for your time and consideration.
Thank you. And Ms. Atlas, are you still there? I was going to ask her to spell.
Yes, I am.
Could you spell your name, please, for the record?
Yes, it's JENNIFERATLAS.
Thank you so much. Next caller.
Chair, there are no other callers to testify in opposition at this time.
Thank you. Then I will go ahead and open it up for testimony in neutral. If there's anyone that would like to testify in neutral here in Carson City.
Hello, Will Adler for the record with Silver State Government Relations, representing Green Thumbs Industries, or GTI. GTI wants to be neutral on this bill at this moment because it is a very large bill, and the amendment came out very recently with a lot of improvements to the original language, but there's still maybe some points of concern baked in there, but there's a lot to digest all at once. So, yeah, thank you. Somebody got it. All right, well... Okay, nobody. All right. Well, let's not get into the weeds on this one, but okay, all right. But there are a few things also points raised by Erica Roth, Assemblywoman Roth, there about exit bags and other additional packaging. There is a lot to the cannabis industry in Nevada. We actually have probably the most stringent and regulated industry when it comes to child-safe packaging, imagery, and the whole of it. So we like the efforts put forth by the amendments with the CCB and are reviewing them now and hope to come to a firm support conclusion soon. Thank you.
Thank you for that, Mr. Adler. And I know that neutral is often a tricky testimony to give, but I would like to say that was a great example of what a neutral testimony is. Thank you for that. Is there anyone else that would like to testify in neutral? Not seeing anyone. There's no one in Las Vegas. Broadcasting, is there anyone on the line, please?
If you would like to testify in neutral for Assembly Bill 76, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify in neutral at this time.
Thank you for that. Then I will close testimony and welcome the sponsors back up if they want to make any brief final remarks.
Just wanted to say, James Hum for the record, just wanted to say thank you so much, Chair and members of the committee, for the opportunity to present today. I know obviously there was concerns from Assemblymember Yerk, so we will reach out to him and discuss that section of the bill that he had questions on. Outside of that, again, just want to thank you so much for hearing our bill and letting us propose our amendment. Thanks, Chair.
Thank you so much. With that, I will go ahead and close the hearing on Assembly Bill 76 and open public comment. Again, our number today is 1-888-475-4499, and the meeting ID is 860-3620-6466. And again, would just like to remind everyone that public comment is for issues that are under the purview of this committee and really should not be about bills that we've already discussed. But in addition, this committee is not the appropriate venue for all topics. We do not have jurisdiction to discipline over employees, including peace officers, judges, government employees, or any other specific person. So with that, we ask that you refrain from making references that identify specific individuals. With that, again, I also ask that you keep your comments to 2 minutes. We will start here in Carson City if there's anyone that would like to make public comment. Not seeing anyone. Not seeing anyone in Las Vegas. Broadcasting, please open the line.
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now to take your place in the queue. Chair, the public line is open and working, but there are no callers choosing to provide public comment at this time.
Okay, thank you for that. So, sir, I believe we have a first-timer making public comment?
Truly first timer.
Okay, so, yeah, I started in Carson, but you're here to make public comment. Please proceed. Just say your name, spell it for the record, and we ask that you limit to 2 minutes, okay?
My name is Teddy.
Oh, and turn on your microphone.
My name is Teddy Craig. I'm from Catfish Kickstart Program. I have an appointment with you, but it's way in March, and I'm coming about this John Walsh law. They have bunched everybody up into tier 3s, and it's kind of like an overload upon society as well as the P&P department. The parole and probation department, they usually only have 7 or 8. Now they got 36 and 38. We have pedophiles that's running around out there that can't really be watched because their load is so heavy. I did 22 and a half years in prison myself. I took all the programs. I thank all the legislation and all the boards. They applied the money for it. But now Lovelock is the sex offender prison. There's no programs because no one is into a tier level. Working out there is hard for them to get jobs. I do a Catfish Kickstart program where I catch inmates coming out. I try to help them find a job, a place to stay, and give them some clothing. So far, I'm betting 100 on the jobs, but I'm fighting the tier 3, those that have done something that makes them a 1, they are now pedophiles. When they look it up on the register, they're listed as pedophiles when they was a tier 1 before. I went in as a tier 1. Now, courtesy of me saying no to one of the officers, well, the psych department, he came at me wrong, and I told him no. And he told me I was never getting out of prison. He got caught in a room with someone else, and I'm in front of you today, pleading for those that are caught up under this John Walsh law. All I'm asking is, please go back to the way it was, tier 1, 2, and 3, before everybody became 3s. I'm not asking to do a whole new law or anything. I'm just asking to revamp the law the way that everybody took the time all these years to implement it. You went through all these tests, had all the psych department go over everything, and it was tier 1, 2s, and 3s. If you took classes and programs, your tier can be brought down. And then that way, P&P can keep the eye on these pedophiles that's out here lurking on our children, because I have a business in this town now, and this is my town. And other than they watching this whole big bunch of people, because common sense, you can always watch 6 or 7 people, but it's hard to watch 48 and 49 people.
Yes, and sir, I'm going to ask you, we're over time, so if you could wrap up your comments.
Yeah, and just one, how can a female be in prison 2 years and get 6 months pregnant? The system is corrupt. I'm Teddy Craig, Catfish Kickstart Program. You can always find me through Mr. Jackson in 4111. Thank you for your time. I appreciate each and every one of y'all, and I'm just here trying to do my best as a citizen of Nevada.
Thank you so much. And with that, we will go ahead and close public comment. We have finished our business for the day, so I will adjourn this meeting and see you all tomorrow at 8 a.m.